Okay, so let's talk about rear-end collisions. They seem like the most black and white accidents out there. The car behind is always at fault, right? Well, in this explainer, we're going to dig into why that simple rule is really just the tip of the iceberg of a much more complicated reality.
So let's just jump right in with the question that, honestly, almost everyone thinks they have the answer to. If you get hit from behind, it's got to be the other driver's fault. Yeah? Case closed. Move on. Well, it's not always quite that simple.
And look, for the most part, that common wisdom is spot on. This quote right here, it really gets to the heart of the whole legal principle. I mean, it's pretty simple. Every single driver has a basic duty to see what's in front of them and, be able to stop in time. It's like the golden rule of the road. But, and this is a big but, the journey from that crystal clear rule to actually getting a successful claim, well, it's not always a straight line. So here's the path we're going to take today to really unpack all the complexities. We'll start with that simple rule, then get into the twist of when insurers argue back. After that, we'll look at some more complicated scenarios, build out your post-accident action plan, and wrap it all up with the big takeaway.
All right, let's dive into part one, the simple rule. We're going to build that legal foundation and see why, on the surface, liability seems so straightforward. And it all kicks off with a rule I'm sure you've heard of.
Yup, it all comes down to the highway code and that famous 2-second rule. And let's be clear, this isn't just some friendly advice, right? It's the absolute minimum safety buffer you need to react and stop in time. And when the road is wet, you got to double it to 4 seconds. And there's a really, really good reason for that.
So what does that buffer actually look like in the real world? Well, get this. At just 60 miles an hour, your total stopping distance, and that includes your own reaction time, is 73 meters. Think about that. That's about 18 car lengths. It's a really stark reminder of just how important that safety gap truly is.
So here's the bottom line. When one of these accidents happens, the blame, the liability, almost always boils down to one of these three things from the driver behind. They were either tailgating, way too close, they were going too fast for the conditions, rain, ice, whatever, or, and we see this all the time, they were just plain distracted.
Okay, but if it's all that simple, why do these claims get so messy? This brings us to part two, the twist. Let's look at how a case that seems totally straightforward can suddenly get challenged when the insurers start pushing back.
All right, probably the most common argument you're going to hear is this one. Well, you braked too suddenly. The insurer will claim you slammed on the brakes for no reason. But here's the thing. The legal reality is that the entire reason the 2-second rule exists is for that exact moment. It's there so you have enough time to stop, even if the car in front has to brake hard for some unexpected hazard.
Here's another one you might run into, the low-speed impact argument. The insurance company might say something like, "Come on, it was just a tiny bump. There's no way that could have caused the neck or back injury you're claiming." Basically, they're hinting that you're exaggerating. But the law has a really powerful answer to that, and it's been around for a long, long time. It's called the thin skull rule. And what it means is that the at-fault driver is responsible for the harm they actually caused, even if the person they hit was more vulnerable to injury. To put it simply, someone else's pre-existing conditions don't give you a free pass for being negligent. Okay, so now let's crank up the complexity a notch. What happens when it's more than just a simple 2-car bump? Welcome to part 3, the escalation.
All right, let's picture this. You've got a standard 3-car pileup situation. Car A is at the back, following car B, and car B is following car C. Simple setup.
Okay, so driver A doesn't stop in time and, bam, hits car B. That's the first impact. This is the moment that sets everything else in motion, like the first domino falling. Now the force from that first hit shoves car B forward and, crunch, it plows right into the back of car C. In a classic chain reaction like this one, it's pretty clear-cut. The driver who started it all, driver A, is usually on the hook for all the damage that happened down the line. But the stakes get so much higher when you bring a heavy goods vehicle into the mix. We're talking about a massive difference in sheer weight and size. That means the forces involved in the collision are just astronomical. It's a whole different ballgame, often leading to much more serious injuries and incredibly complex claims. So, after hearing about all these potential complications, you're probably wondering, what can I actually do if this happens to me? Well, that brings us to part 4, the toolkit. Let's build your post-accident action plan right now. All right, here is your 5-step plan. Step 1, preserve your evidence. That means photos of the damage, and if you have a dash cam, save that footage immediately. 2, exchange details. You need their name, address, registration, and insurance info. 3, and this one is so important,
Get medical attention. Go see a doctor, even if you feel okay. It creates a record. 4. Witnesses. If anyone saw what happened, get their contact details. And finally, step 5. Get specialist advice from a solicitor, and do it quickly.
And look, out of everything on that list, these two right here are your absolute game changers. Your dashcam footage, that can kill that whole sudden braking argument in an instant. And your medical records from right after the accident, they create a powerful, undeniable link between the collision and your injuries. They are your most powerful tools. Okay, let's wrap this all up and get to the most important takeaway from all this. The one thing you really need to remember if you're ever in this kind of situation.
Here it is, the central message. Liability is usually simple, but proving your claim can be complex. You see, figuring out who's at fault, that's often the easy part. The real battle is proving everything that goes along with your claim. Think of it this way. That simple liability rule just gets you pointed in the right direction. It's the quality of your evidence that actually gets you to your destination.
And that really leaves us with this final, crucial question to think about. Yeah, liability might seem clear as day, but is your evidence strong enough to stand up to all the complexities we've talked about? Because in the end, it's not just about who's at fault. It's about whether you're ready to prove your case. Being prepared, that's your single greatest asset.